My Lord, I was going to go next, if I may, to looking at what we say the legal principles to be applied, the legal approaches to be applied in deciding the nature and scope of what the Minister needed to know about in terms of materials.
Yeah.
You'll have seen that in our skeleton we identify three routes into this. One is around section 104(2)(d of the Planning Act, one is around consultation, and one is around the evidential need for findings, a more general public law proposition. Can I just develop those slightly? The middle one is the one that's going to take me the most time, if I may. One in relation to section 104(2)(d, the judge dealt with this by saying that there was a complete answer in what the Supreme Court said in Friends of the Earth, which you have in Appeal Bundle 43, tab 43, sorry, Authority Bundle, tab 43, starting, the report starts at 1761. The relevant section is page 1792. And this is all material that will be very familiar to the court, but this is the place which is drawn together relatively recently by the Supreme Court, and this is where the judge referred to. Paragraphs 116 to 118, bringing together familiar analysis from cases going back to Creed NZ, New Zealand Court of Appeal, and dividing up considerations into those that are informed by the statute and others, and three categories. This is paragraph 117. Those things which the statute impliedly requires to be taken into account, those things which the statute impliedly requires not to be taken into account or to be ignored. And then category 3, those which the decision maker can take into account in the exercise of their discretion. And paragraph 119, what the Supreme Court said in the general case, and that's important for our submission, is that the test for whether a consideration falling within the third category is so material, so obviously material it must be taken into account, is a familiar Wensbury test. In other words, would it have been irrational for the decision maker not to take it into account?
Yeah.
And what we say is that that has to be seen in this statutory context, underline, in the context of section 104(2)(d, which I've already had some points in relation to, which, as the court will recall, requires the court, the Secretary of State, here the Minister, to take into account those things which he considers to be relevant and important. So it sets up a test. So it gives him a discretion which is important, and it necessarily implies, we say, and this really is the point, that he is aware of a wider category of information than that which he couldn't rationally leave out of account, which is the formulation of obviously material in paragraph 119 in the Supreme Court.
Could you say it again? It indicates that he must be aware of a
wider category of information in order to exercise the discretion. Otherwise the 104(2)(d) simply collapses into obviously material, and it therefore contemplates a situation in which a decision maker would only be told about those things which he couldn't rationally leave out of account. And that would rip the guts out of the 104(2)(d) exercise. Now, the question my Lord Justice Stuart-Smith put earlier on, how do you know what else there is? We say this has to be seen, and the point I made earlier on, I think when the question was asked, in the context of a statutory scheme which is premised on a prior process of examining authority informing the Secretary of State performing a filtering exercise. Now, even if we're wrong on the, let's call it the redetermination point, JR ground 1, and there didn't need to be an independent inquisitorial process, it could be done by officials in the way it was done, there is still a problem, and we say illegality, if all that the officials give the Secretary of State, here the Minister, is those things which no Minister could rationally leave out of account.
Why?
Because that has...
It may indicate they've done their job absolutely perfectly.
but it's taken the discretion away from him. It's removed his ability to say, I think I want to take into account this additional thing, which I'm lawfully entitled to taking into account on conventional Creed NZ principles, and which the statute requires me to consider whether to take into account. C104.
Where does this stop? You accept that it's right for the officials to act as a filter, to filter out irrelevancies.
Well, yeah,
up to a point.
Up to a point, yes.
Up to a point. So, if as a matter of fact they have filtered out everything which is not necessarily material, what's wrong with that?
Well, the answer may be in the relevant and important test, because those are important statutory words, because they cast a test for the minister to consider that which is relevant and important, which may be different to that which, in the irreducible minimum, you might say, absent 104.2d, a decision maker might rationally decide not to take into account. But the important thing here is the statutory overlay.
But this is like the old biblical thing about Lot's wife. I mean, if the officials give the minister all that is necessarily material, so all category A, and 50 things that the minister, out of the thousands of documents, and the minister then says, no, I don't want any of those, that's okay. If 50, 10, 5, 2, 500, all, you end up surely saying that the end of your argument necessarily is that the minister must consider everything.
No, my lord. That's why I keep coming back.
Case, I'm sorry.
So first of all, can I just make a prior point, if I may, which is you can see this point, and I'm going to move on to the next one in a minute because this is quite a discrete point. You can see this argument as arising in two different ways. Either as, if you like, almost a fewings category one, a Supreme Court category 1, implied by the statute.
Yeah.
So you don't even get into category 3. The statute implies, so we're not into category 3 at all, we never get there, that the minister has to see enough to enable him to make a decision on what's important and relevant. So
the question is, what is enough? I mean, he can't be sure unless he reads every single page that there's not something tucked away in a footnote which is crucial.
I understand that, my lord, and that's why I'm going to come in a moment to the consultation cases, where in effect, what the courts do with consultation cases is to look to see whether the decision maker has conscientiously considered consultations. It applies exactly the same proposition that the decision maker has to. It's only what the decision maker knows themselves, not what their officials know, and it explicitly in some cases and implicitly in others, and I'll show you examples of this, looks at the category of materials that the decision maker needed to have summarised to them by officials. I'll come to that in a moment if I may. If I could just signpost that's where this goes, because these points do sit together.
But the summary isn't going to be enough when we're looking at the statute, because the summary may be a very interesting and helpful suggestion about what Mr Goggins on floor 2 thinks. But he's not taken the decision. The Secretary of State needs to know the raw material to decide if the raw material is relevant and important in your scheme of analysis.
Well, and I take my lord's point about where do you draw the line, but as we'll see in the consultation case in a moment, the courts regularly and routinely, not routinely perhaps, regularly do exactly that exercise without necessarily explaining exactly how they're drawing the line, which is to work out that which could never have been said to be a mandatory material consideration in the sense of obviously material, you had to know it, if it wasn't in a consultation kind of situation. Here, before we get to that, I simply make the point that this is a Planning Act situation, and that's why I started the morning by talking about the nuanced regime of the Planning Act. It contemplates the parliamentary framer of the Planning Act put in place 104.2d, contemplating that in the cases the statute was dealing with, which are not the quashed ones, the first time round ones, there would have been an examination in play. So that moderates or provides a framework for our answer on 104.2d. There's no more I can say about it than that. I'll go on, if I may, to the consultation context for all of this. Can I pick up a case called Stevenson? It's in tab 34 of the authorities bundle. It's a decision of Mr Justice Dove, but it helpfully picks up some others in this context, including Kohler, which is a decision of my Lord Justice Lindblom, Lord Justice Lewis, which I'm going to come to shortly.
Can you give us a page?
1235, tab 34.
1235.
1235.
Thank you.
So the context here was a consultation about amending the National Planning Policy Framework. If I can just pick it up in the head note for a moment, so in this context, talk fracking, as they were called, had put in a consultation response to this consultation, which the minister was not appraised of. That's that signpost where we're going. And the argument, which is a prior sort of stepping on the way to that, run by the Secretary of State, was to say, well, your response wasn't on an issue in the consultation, it wasn't a live issue. And that's why we see a little bit of what we see in terms of the preamble to it. But obviously we're not concerned with that question. We're concerned with what the court then said about whether the minister needed to know it anyway. Can I look at the head note and ask the court in holding para on page 1236 to read down to letter D, if you would. And then I'll show you where the judge picks that up.
Yes.
So, my Lord, but in the body of the judgment, paragraph 2, just to set the factual context, the judge sets out the paragraph of the NPPF, which is a document with many, many pages, paragraphs, the paragraph about which the talk fracking response was particularly concerned. So it was concerned with one paragraph in the entire document. In relation to that paragraph, see paragraph 14, 1.4, talk fracking, the claimant had a report, an expert report. We're not concerned with the substance of the expert report, but an expert report which was a challenge to the content of that paragraph. At 19, we see the consultation questions, some of which were very focused, but one of which, Q37, which you see towards the top of page 1246, do you have any other comments on the changes of policy in chapter 17 or any other aspects of the text of this chapter? So it's an open question. And the prior point, which we're not concerned with here, but you'll see it decided by the judge, is whether that allowed for or had already a priori, if you like, ruled out responses on the particular paragraph about fracking. Paragraph 21 through 24 picks up the substance of the talk fracking response. We're not concerned with that. And then at para 24, we see the summary materials that were provided to the decision-making Secretary of State, including at the top of 1249, second bullet. So the minister is not told about the talk fracking response. The minister's told this: individuals and some interest groups disagreed with policies relating to oil and gas development, including unconventional hydrocarbons. These groups considered that these policies should be omitted due to disagreement with the principle of fossil fuels, shale development and fracking. That was all the minister knew about, amongst many other things, the mob's response, the talk fracking response. Then at 28, above paragraph 28 on page 1252, is the heading, the law. Mr Justice starts to look at the law. In paragraph 33, towards the foot of paragraph, well, in that paragraph, he picks up, obviously Friends of the Earth and Supreme Court, other cases, with the obviously material analysis. last 4 lines of paragraph 33, Mr Warren, the Secretary of State, accepted that in order to arrive at a lawful policy, it would be necessary for the defendant to take into account obviously material considerations when establishing national planning policy. That then leads into 35, picking up the common law framework around consultation and what the Supreme Court said in Moseley. Leads on to then paragraph 36, the complaint the claimant made related to the ignorance, the minister's ignorance of the talk fracking response as a consultation response in the context of deliberations around obvious materiality. And that in turn, I'm not taking the detail because these cases are elsewhere, led to a looking by the court at the Pico Wallsend case, which takes us back to the minister's knowledge and the obvious materiality question. And we simply say that line of thinking, which I've taken quite quickly because the details are all there, namely that in a consultation case, the question of obvious materiality is looked at through the prism of the need to conscientiously consider consultation responses. And we'll see examples of that in a second. So paragraph 39, you've got these other cases in the bundle if we need to look at them. Paragraph 39 is the HS2, one of the HS2 cases, looking at a consultation response. If I just pause on 40, not simply because it's a decision by Lord Justice Lindblom and, as it was then, Mr Justice Lewis, a case called Kohler, and Lords may remember that, about police station closures. You've got it in the bundle elsewhere.
In our leisure, you want us to read 39?
I don't think you need, I think you'll get more from 40, and actually from the quote in 40. I could take you to Kohler if we need to, but I think the guts of it is here.
Speaking for myself, this is not a case that I've read before.
No. So Kohler, my lords may recall, and it's summarised by Mr Justice Dove there, I think correctly, was a consultation case about police station closures, in the course of which the Merton Liberal Democrats, Mr Kohler, had put in a response saying, don't close the police station, it's premature to close the police station until the new technology that you say will replace the police station is up and working. That was the whole of the point. And the court said this: we're satisfied on the evidence, however, that there was one matter raised in the consultation responses related to Merton that was not discussed or considered at the meeting. That was the proposal advanced by the Merton Liberal Democrats that it was premature to take a decision to close the police station. 4 lines down, it was undoubtedly fell within the scope of the consultation exercise, not being suggested otherwise. Questions asked invited comments about the opportunity to contact the police as an alternative to a front counter, etc. 68, the summary of consultation responses did not refer to that proposal or suggestion. On the evidence, we cannot be satisfied the Deputy Mayor herself read the Merton Liberal Democrat submission. Now, several important things in there. Now, we can look at the original judgment if we need to. But first of all, the approach the court took to the Deputy Mayor, and what she needed to know, it wasn't suggested, and the court didn't analyse it on the basis that it was an obviously material consideration to know about a suggestion for a premature closing. But it was a perfect, proper consultation response, and omitting it in the briefing was fatal to the decision.
The problem there was, from recollection, the person who was taking the decision, who was the Deputy Mayor, didn't know about this proposal at all. And we're dealing, as I said before, lunch, with a different situation. The material has come in the course of a Rule 20 process, and we know what the Rule 20 was about, because it tells us at the start. That information has been analysed and translated into the form of a draft decision. And the question then, surely, is whether the draft decision adequately deals with the points that's raised. In this case, for example, say a draft decision had gone to the Deputy Mayor and it said, we do not consider that we should postpone the closure of the Wimbledon police station because there's an urgent need to save money. That would have been the answer. It's a different problem.
Well, it is a different problem, but it raises this. It's a different factual context. I obviously understand that, but I don't think it raises a different problem, because the problem with the Merton case is that in the Merton case, the briefing had not made mention of, and so the Deputy Mayor would not have been aware of, this point being made by consultees.
Yeah. So if, for example, nobody knew that Stonehenge Alliance had written in saying, actually, there's a better transport alternatives, and the officials didn't know about it, and the decision letter didn't refer to it in draft, then that would be the same. But here you've got a process where the Rule 20 says we want information on these matters and anything else you want to tell us. That is sent in by the bucket load. Somebody has gone through that and worked out what is relevant and important.
And in the Merton case, officials had gone through consultation responses, which came in by the bucket load, and had worked out what they were going to tell the Mayor about. The difference between the two is that in one instance it was done by a briefing to the Mayor, which was in the form of a briefing on consultation responses. In this instance, the present case, it was done through a draft decision letter. But that's not as mentioned, that's not a material difference. The issue is the court's approach to the omission in the materials seen by the decision maker of consultation responses.
This sounds as if the submission now doesn't seem to be rooted in material or immaterial or mandatory considerations. The submission now is that the process of central government decision making requires, in this context where there's been a Rule 20 process, that there be an adequate summary of all the material in the Rule 20 responses.
Yes. Well, you can put it that. We can put it that way. And
hold on, then let me write that down. Just
adequate summary.
No, hold on.
Sorry.
I mean, there have been other recent decisions of this court on that topic. I mean, you're going to take them to take us to them, are you? Or?
I wasn't. I'm not sure what my lord has in mind, and if there are cases that I haven't picked up, the other side hasn't picked up, then. But absolutely, in the sense, adequate summary is right, because in a consultation case, it's well established that a decision maker doesn't have to read every consultation response. They have to have an adequate summary.
What I've written down is, for the decision by the Minister be lawful, he must be provided with an adequate summary of the responses to the Rule 20 invitation.
Yes. And the question is how you approach adequacy. And my simple observation is that the courts do that, see these cases, and they're summarised there. You've got them elsewhere in the bundle, without.
I've got a feeling there is a court review decision within the last 2 months on that topic. I can't remember the name of it, but it sounds as if it
sounds helpful or unhelpful.
Well, I don't know. I mean, I might be misremembering, or they might have said it wasn't necessary to decide, but we've got to have the relevant authorities if there are any. Yeah.
So adequate summary then becomes a different question, and one has exactly the same difficulties about where you draw the boundary around adequate summary, and in the end the court looks at it and says, well, that's inadequate. So the examples we have are you've got them here. Mr Justice Dove goes from a recognition that the question is obvious materiality, but in the context of a consultation case, obvious materiality is informed by, if not driven by, adequate summary. We've got examples like Buckinghamshire and Kohler, where without grinding down into the obvious materiality analysis, the court looks at and decides for itself, at least on the individual points, Merton Liberal Democrats' submission on prematurity was not adequately summarised. And what we say, and I'm going to come to it, of course, shortly, is that the points which we give the court examples of in, for example, the Stonehenge Alliance responses were not adequately summarised, and I understand that's where we need to get to. Well, the third way in which we approach this question is in relation to a completely different public law concept, which is the need for evidence on a point. Somebody making a public law decision has to be appraised of the evidence on the basis of which they're making that decision. You've got Lancashire in the authorities bundle at page 1734, but that in a sense is simply Edwards and Bairstow, old classic public law. But you have also got in authorities bundle tab 17, the National Health Food Stores case. It's authorities bundle 17. starting at page 497, within it at 502.
This is such an important case. Has it never been reported?
I don't think so, but I might be wrong about that. It is a case to which we often come back.
Quite. Okay. Sorry, I've just
No, I don't.
insatiable curiosity. Sorry about that.
27. In contrast to Coltona, where this court gave legal authority to the practical reality of modern government in relation to devolution of departmental functions, the doctrine from which Mr Kavanagh contends does not, certainly to my knowledge, reflect the reality of modern departmental government. The reality, and this I think picks up a point that my Lord Justice Lewis was raising earlier on, the reality, subject no doubt to occasional lapses, is that ministers or authorised civil servants are properly briefed about the decisions they have to take, that in the briefings, evidence is distinguished from advice, and that ministers take some trouble to understand the evidence before deciding whether to accept the advice. I'll come later in this judgment to the critical question of how much of the evidence the minister needs to know, but I cannot believe that anybody, either in government or amongst the electorate, would thank this court for deciding it was unnecessary for a decision maker to know anything material before reaching a decision. So that's the point about briefings, and does reflect...
I mean, what was the context here? Did the minister himself... It's no good reading out a sentence saying apple pie motherhood is good. What were the facts? Did the minister know? This case seems to be all about something that he positively didn't know about, and they were trying to argue that because somebody did know about it, it was enough. I mean, what was actually said to be the illegality here, and how does it correspond to our case?
The illegality was in the extent of the briefing to the minister. I think it's actually relatively well summarised in the judge's judgment. So the point here is that it was an issue about expert evidence on a regulatory question, and the complaint was that the minister hadn't known the full details of a submission made on behalf of a particular expert.
And I thought they decided that he didn't need to know about it.
He didn't need to know everything, but the point was he actually knew the critical elements of it. I'll come back to that if I may.
This goes back to Pico Wallsend, doesn't it, in the High Court of Australia?
It does. I'm simply looking at the briefing and evidence point, and we accept fully that civil servants are entitled to summarise things for officials and give advice. But again, they all come back to relatively the same place. Here we're looking at the evidence known to the decision maker. The minister, decision maker, can't simply, we say, adopt raw conclusions of the civil servants without any of the supporting understanding.
Is it that passage of Chief Justice Gibbs' judgment in Pico Wallsend, quoted by Lord Justice Keane at paragraph 73 on page 515 that really captures... What, 515?
Yes.
That really captures the point.
That, indeed. I mean, I'm not saying that captures the whole point, but that's one of the ways in which it's put. Absolutely,
it captures a good deal of the point.
Yes.
But then don't we need to look at the letter here, the draft decision letter, which presumably became the decision letter, because if that does, as it said it was going to do, set out the recommendations and in fact what became the decisions and the reasons for it, if that does adequately cover the issues that arose on the Rule 20, then it's all right. If it doesn't adequately cover the things on Rule 20, then it's not all right.
And that's exactly where I'm going next, Willard. That's exactly where I'm going next.
What this case should really all be about is whether the decision letter addresses the issues that were raised. Did it deal with transport? And that's a separate question from whether or not he had to have another document or to have read every document that dealt with transport or the 4 heritage assets or the other things that you've hinted but haven't yet listed as being matters that weren't dealt with.
I absolutely agree with that, my lord. Absolutely agree with that. Absolutely agree with that. And I'm sorry if my submissions take several hours and I can't deal with the whole point in one. So, my lord, those are 3 subtly different but overlapping routes into assessing exactly the question that Lord Justice Lewis is contemplating. These matters are set out. I'm not going to go through all of them because time doesn't permit, but they are identified in our skeleton argument. So to some extent I'm going to give you references to our skeleton argument if I may, but take you in a little bit more detail for some of them.
Yes.
Please don't take that as abandonment of the points.
No.
So paragraph 27A of our skeleton argument. I picked up most of this already. I'm not going to go through the detail of it. I'll give you the headline. Minister wasn't briefed on why the Stonehenge Alliance said the examination process should be reopened. I've shown you the materials on that. Secondly, 27B, and I'm going to go into some in a little bit more detail in a moment, wasn't briefed on our submissions that the Longerboard Tunnel would bring significant benefits to wildlife.
Is that the stone code?
Exactly, which had been accepted or not disputed.
When you say accepted or not disputed, do you mean by other people in the Rule 20?
By
or
National Highways.
By National Highways, okay.
C, not briefed on submissions on why the new, and that's to some extent material, information on traffic forecasts couldn't be relied on. So this is not stuff that the examining authority would have looked at, because it's post the examining authority's determination. It included issues around COVID. And just to pick up the last sentence, in paragraph 27 on page 10 of our skeleton, the Minister was entirely ignorant of us making those representations. They may be bad points. They may have been bad points. It's not for the court to second guess the merits of those points. The Minister was simply unaware that we were saying don't rely on these forecasts because of the implications of COVID. And that's a classic consultation response.
So
Then we come to the consideration of alternatives. And I've already shown the court the way in which this issue differed from others.
Can we just be clear, when you say the inadequate briefing, do you mean the draft decision letter? It's just a factual question. The words inadequate briefing mean what by reference to the documents in this bundle?
All of the documents the Secretary of State can be taken to have read for the purpose of his decision. So the ministerial submission, the draft decision letter to which it referred, which he was specifically, those bits of ES that were put in the supplementary, the follow-up emails. We're not trying to be clever about that description. And that's why this does relate to the question of what the court takes the minister to have read.
So the alternatives were left out of account. When I read the decision letter, the draft decision, there'd be nothing there about
No,
alternatives.
I didn't say that. I don't think I've made that submission, my Lord. We're coming to that. There is stuff on alternatives, but we need to look at it in the way that my Lord's invited me to. We need to look at it with a close eye to see how it stacks up against the materials.
Right.
So 32A picks up Stonehenge Alliance submission on alternatives.
32A of your skeleton.
I'm
I
sorry,
haven't
my
got
Lord.
a 32A.
I haven't got a skeleton. No,
I'm sorry.
32A.
But my
32.
32 of our skeleton. Sorry,
Yeah.
what did I say?
You said 32A, but
Oh, sorry, 32.
the supplement's
32,
reminding
I'm
you it's
sorry,
just
apologies.
32, actually.
The document which is being referred to is in the supplementary hearing bundle number 2. Page 258. The heading, section 5.3, is F10 surface route option to the south. And there are 2 points, 5.3.1 and 5.3.2, about heritage impacts. Our point, drawing on National Highway's own materials, the references are given there, was that F10 would provide significant benefits for the World Heritage Site. That's the quote in 531. And the quote in 532, again from National Highway's own materials, was that F10, there was a large beneficial effect for F10 in terms of the World Heritage Site. So those are quite simple headline points, and I want to look at how those play out in terms of what the Minister was told. 533, foot of the page, F10 would be far less expensive than the proposed scheme. And again, a reference to National Highway's own materials. It is several £100 million cheaper in a context in which one of the factors said to be weighing in favour of the scheme against longer tunnel examples was it was several £100 million cheaper than longer tunnels. So a clearly relevant question, cost. Then 5.3.4, there's a quote from National Highways where they say, like a point going against F10, would have a much larger footprint and a greater overall environmental impact than partially tunnelled options. And then the return to the text of the representation. Apart from the larger footprint, these assertions are not substantiated by any firm evidence. National Highways has failed to provide any assessments which back up its bold assertion of greater overall environmental impact.
Where are you?
I'm sorry,
Sorry, I'm on page 259. But
259, it's the first full paragraph, about a quarter of the way down the page.
Yeah, apart from the larger footprint.
Exactly. These assertions are not substantiated, fail to provide any assessments which back up the board assertion. The term environmental impact covers a multitude of potential impacts. So that is questioning the nature of what was being said as a disadvantage of F10. But the previous examples, 531, 532 and 533, are all advantages of F10. And then 32.5 in our skeleton, 535, further down the same page, NH acknowledges that Corridor F options have not been investigated to the same extent as the World Heritage Site. There's a higher degree of uncertainty as to what archaeology might be present. We are advised by Professor Parker Pearson that the route, F10, is known to pass close to 3 scheduled ancient monuments, 2 separate round barrows and a site of tumuli. Otherwise, no known archaeological sites are affected, but does not otherwise affect them. Otherwise, no known archaeological sites are affected other than areas of field systems, similar to those ... There is no evidence that this southern alternative route can be considered as having any notable archaeological significance at a local or even regional level. So the earlier materials are picking up National Highways material. This representation is in relation to an external expert whose view, right or wrong, is that F10 does not have any notable archaeological significance at a local or regional, I think. Now that might be wrong, he might be wrong, but the Minister needs to know that.
I'm just not with you at the moment. Are you for or against, or what does paragraph 5 mean?
Paragraph 5.3.5?
Yeah.
It is pointing out that this expert says that F10 doesn't have archaeological heritage impacts at a local or even regional level.
Yes.
In other words, heritage isn't a factor against it. Indeed, if we just chain that back to 531 and 532...
Now, hold on. If that's the case, I'm trying to understand what paragraph 32.5 has to do with your case that the Minister wasn't briefed.
So the Minister wasn't briefed, let me just go back a step, at 531 and 532, on page 258. He wasn't briefed that National Highway's own case is that F10 is significantly advantageous in heritage terms. This is almost...
But this contradicts.
No, it doesn't contradict.
3.5 point whatever, is it? This evidence of Pearson contradicts.
No, it doesn't contradict. It sits happily alongside it because so 531 and 532 are about the relative effects.
Yeah.
And the conclusion of National Highways was that F10 would provide significant benefits for 100 scheduled monuments. That's a specific, relatively narrow point, but important nonetheless.
Yeah.
532, overall, large beneficial effect in heritage terms. Parker Pearson is dealing with another version of the heritage point, which is to say, and another thing, F10 wouldn't have any impact on heritage assets of a significance at local or regional level. They're all consistent with each other, all reasons to either to prefer F10 on heritage terms. And I've jumped over, although we saw it as we went through, far less expensive.
So it supports your case that F10 would be better because it doesn't do any harm.
And indeed, it would be better. F10 would be better in heritage terms. Large beneficial effect for the World Heritage Site.
No, I'm just trying to understand.
Yes, yes,
I
yes.
find the skeleton difficult to understand as a matter of English. It's my fault entirely. But I'm just trying to work out what it actually means so then I can understand it and put it in the context of this case.
Yes.
But I now understand it to be saying that the evidence of Professor Pearson supports your case that F10 is fine because it shows that it doesn't damage scheduled monuments. It passes close to scheduled monuments. It wouldn't otherwise affect them, and there was no evidence that would do any notable archaeological.
Yes.
That's it.
Yes.
So F10 would not cause harm. That's all. Yep, I've got it. So the Secretary of State should have been told that one professor thought it wouldn't cause harm.
And
Yeah.
significant benefits, 531. Large beneficial effect, 532. Far less expensive, 533.
Yeah, we've got those. It's paragraph 5 that I was trying to understand. I've got it. Thank you very much.
Well, can I then go to the decision letter which picks this up? Paragraph 230. With regard to F10, this is at page 647 of the core bundle. So this is the Minister's briefing on F10 in the form of a draft decision letter. With regard to route F10, while a surface route that bypasses the WHS in its entirety will avoid the less than substantial harm to the WHS from the proposed development or alternative above, it will give rise to other environmental effects, including heritage impacts. In particular, there will be likely to be direct physical impacts to the southwest corner of the WHS, impacts on yet undiscovered archaeological remains that contribute to the OUV of the WHS, impacts to the setting of the WHS and barriers within the WHS that contribute to the OUV, and harm to the settings of other scheduled monuments, Grade 1 less churches, conservation areas, etc. Because of these potential adverse effects of Route 10, the Secretary of State does not prefer it to the DCO scheme. Just taking that in steps, the Secretary of State is told nothing about cost and that this would be far less expensive than the proposed scheme. And just to put that in the context of another paragraph of the decision letter, paragraph 221 of the decision letter parades the advantage of the proposed scheme over a longer tunnel scheme as being cheaper. So cost is a matter which the Secretary of State is looking at in that evaluation.
So your reference there was?
221.
Yeah.
So 221, he's told about that the National Highways scheme is cheaper than a longer tunnel, but he's not told that F10 is cheaper still. He also, from reading paragraph 230, he would also have gained the impression in our submission that there was a heritage opposition, a heritage reason to refuse, to mitigate against F10. But that is because the characterisation in 230 focuses on some elements of heritage impact outside the context, without telling the Minister, of the overall assessment undertaken by National Highways themselves of a large beneficial effect. It gives him completely the opposite impression. It gives him the impression there is a heritage reason to refuse, rather than there being a large beneficial effect, which is actually what the position was which we'd drawn to their attention.
Can I just ask you, I think I must be getting confused. I had in mind that at the original examination, Stonehenge Alliance did not advocate in favour of F10.
That wasn't their preferred alternative.
It wasn't their preferred alternative. What was their preferred alternative?
Longer tunnel options, or another modal alternative.
And when it came to the redetermination, what was their position?
They put a wider case of more alternatives, including referencing F10.
Were they advocating for F10?
Well, in effect, they're saying it's a preferable alternative to the proposed one. Yes, in that sense, advocating for it. And
what was their preferred route? Or is this? I'm just going to put this tendentiously. Or was this merely a destructive approach?
This would be a preferable route preferable alternative, because there are non-route alternatives to the government the National Highways proposed scheme.
So position changed between the original DCO and.
Well, look, Ms Hutton may prefer to deal with it.
Okay, if it's her department.
My Lord, it's correct that at the examination it was mainly the modal shift or longer tunnel that was supported by Stonehenge Alliance, but they didn't actively not support F10. During the redetermination process, the National Highways submission became very focused on the cost of longer tunnels, and it was in that context that the Stonehenge Alliance highlighted, well, then you've got a much cheaper alternative in the order of £400 million, which is F10, which is much less harmful as well. And so it had a greater focus on F10 during the redetermination process than it had done during the examination. But my Lord, during the examination, Stonehenge Alliance did point out that not enough work had been done on F10, and there wasn't enough evidence to support it having been discounted by National Highways, and I can find the reference for your Lordship.
Thank you.
Yeah, and indeed, the point Ms Hutton just makes was referenced by the examining authority in their consideration of options appraisal earlier on. But Lord, in one sense, whether well, I think the point's been answered.
And can you
Sorry.
clear to me? I mean, part of the problem is very, very difficult coming to this. None of this seems to be foreshadowed in a way that I found easy in the skeleton. But you're relying now, it appears, from what you just said, on a national heritage or National Highways assessment that says this is cheaper, unless I've misunderstood that as well. Now, what is that National Heritage Highways assessment? Was it something that went in as part of the redetermination? Was it something that went in as part of the original thing? It's impossible to work out what's gone wrong, if anything has gone wrong.
Just for my Lord's note, if you want it, the footnote 27 of our skeleton gives you the references to where you would find the figures. Just look at footnote 27.
So National Highways were saying that it was some 400 million.
Cheaper.
Sorry. 400,000.
400 million.
400 million.
That was right the first time.
Cheaper.
Right,
Where-
this is in something called the TAR, and that's in the supplementary bundle. So wasn't this a document that National Highways submitted during the process of redetermination?
No, these were documents that had been submitted previously, but this is important,
Yeah.
previously, but because the examination hadn't been concerned with, because of the error of law,
Yeah.
the relative merits of alternatives.
That I've fully understood.
It hadn't
this
been
morning.
reported.
So this document saying £400 million cheaper had gone in at the re-examination stage but hadn't been assessed.
It had gone in at the examination stage, hadn't been assessed. The Stonehenge Alliance is then drawing it to the fore for reasons that Ms Hutton's just given
Yeah.
in the redetermination process.
Right.
That's the cost point. My Lords, but the other.
And does the next obvious question is, does the examination report, even though they didn't assess it, I have that point, you don't need to repeat it, even though they didn't assess it, does the examination report refer to the fact that National Highways had put in this document which said F10 was £400 million cheaper? It doesn't refer to it at all.
So the judge picked this up at paragraph 193 of his judgment. In its written representations to the Secretary of State in April 2022, that's in the examination process, the essay mentioned the cheaper cost of F10 only briefly. The essay's point to the panel recorded in PR 5.4.36, I'll go to that in a second, had already made the point that FC10 was cheaper. Can I just look at that paragraph?
Let's just read 193, read it at huge speed. I'm much slower than you. I need to read it. 193 in its written representations to the SST, that's the Secretary for Transport, presumably, is it?
Yeah.
So this is part of the...
Examination.
Okay, yeah. The cheaper cost, but only briefly.
The point to the panel had already made the point that was cheaper. So 5.4.36 is supplementary bundle 1
Yeah.
at page 16.
Yeah.
It's the point Ms Hutton was just making to court just now. Stonehenge Alliance also criticised the economic appraisal of options in the TAR. Contains that economic analysis does not support the decision to drop F10 since the reduction in benefits broadly matched the reduction in costs. So that was how the panel summarised the position. But they were dealing, as we know, with a different exercise, so I'm not complaining about that, other than that they did the wrong exercise. But what that meant was that when the Secretary of State, the Minister, comes to make the redetermination, he hasn't got the far less expensive point, because all he's got is paragraph 230 of the decision letter.
Well, he's got 5.4.36 as well, hasn't he?
Which doesn't say to him, we're not complaining about that as a summary for the purposes of the exercise the examining authority was thinking it was doing. But he wouldn't have got from that and 230 that this is 400 million odd pounds cheaper. So these are 4 square adequate summary consultation points, if you like.
Does this come down really to a straightforward contention that he fails to take into account a material consideration?
Well, in one sense, yes. That's our ground. That's our JR ground 8. Well, it's called inadequate briefing, but it's the same point. We can characterise it in different ways.
I mean, are you really submitting that the simple flaw here in evident in paragraph 230 of the decision letter is that he doesn't take into account a significant factor, which is a material consideration, namely the 400 million saving in prospect if you create a road at grade by way of a bypass.
And the other points, yes.
Yeah, or together with the other points, but it's that point which is left out.
Well, so that's not the only points left out, what I mean, but yes.
No, but I mean, that's all right, yes.
Alternatively, if he did take it into account, there's nowhere where he explains why that wasn't something that swung the balance. There could be reasons for it.
Absolutely.
I'm struggling to think, why are you getting so much into the briefing? Because
Sorry, I'm not
it's confusing things to my briefing.
So I'll tell you why I get so much into the briefing, if I may, because the other point in 230 is the other environmental benefits, including heritage impacts, so what the decision letter appears to say is the Secretary of State taking into account other environmental benefits. It's got that, if you read the rest of the paragraph, third from the bottom line on that page, paragraphs 21 to 24 of Rep 2/024, which is the National Highways document. So that's where the thinking in 230 has come from. But the Secretary of State the Minister has not seen Rep 2/24 unless he's delved down into the links in the document. He's just picking that up from the briefing document. And in terms of within that, the other environmental effects point, the Stonehenge Alliance submission, which I showed you on page 259 in Bundle 2, took issue with that and said, what other environmental effects? What other environmental effects?
Hold on, let me just analyse that. So,
Well, he says other environmental effects, including heritage impact.
yes.
So if you read 230, it looks like the Secretary of State is making a decision to reject F10, put aside everything else we've discussed, for environmental effects, partly heritage, partly other. The heritage, we know he's got the wrong end of the stick if this is all he reads, because he doesn't know large beneficial effect. But what are these other environmental effects?
Hold on, I mean, just be fair to what he's saying. He says in particular, so we know what the other environmental effects, including heritage impacts, are. In particular, there would be direct physical impacts to the southwest corner of the WHS. I thought that was right, because I thought it went across it. Or does it not go across it?
It cuts the corner of it.
So does it go across it or not? Is it physically on the site?
Well, my lord, can I pick it up this way? The Secretary of State has no more information than this. He's purporting to make a decision on the basis...
There's a different question. Is it physically on the southwest corner of the World Heritage Site, or is it not physically on? It is. So that's correct then.
There's an issue about that. There's an issue about whether it was or wasn't. But the difficulty here is that the Secretary of State, or the Minister, has no more information than this to resolve these contentious issues. And I've shown you some of the submissions that were made by Stonehenge Alliance on these points, of which he's unaware. But he's appearing to reach a conclusion, does not prefer it to the DCO scheme for these reasons.
I only want one piece of information in response to the next question. Please give me the references again, just the references, so I'll go back and check if the things that you say contradict 230 or fail to give it full context.
It's SB, well, it's our skeleton. They're in our skeleton. Paragraph 32.
Yeah.
And then we follow that up in paragraph 33 and 34.
Yeah. So if I read those and the references are clear, are they? And I'll find the documents without any trouble, and I'll be able to see if they support what your solution is in relation to 230.
I hope so. Forgive me if I'm a little slow with this. If I go back to 535 in the response document on page 259, the second supplemental bundle, under the quotation in the passage there, it says it is clear that this route would not cause any loss of the fabric of the World Heritage Site itself. The proposed scheme involves the loss of over 7 hectares.
Yes. So there's a dispute about it.
So there is a dispute.
There's a dispute about the extent to which it impinges.
Well, this implies that it doesn't impinge at all, doesn't it?
Yes.
And I thought that was wrong, he said.
Yes. So National Highway says it impinges on the World Heritage Site. Professor Parker says it doesn't. There's a dispute there. But the Secretary of State's not aware of that.
No, I just wanted to be clear what the factual position was. There's a dispute about whether it does or doesn't.
Yes. And Professor Parker's given his view, might be wrong, but it needs to be, the Secretary of State needs to be aware.
Is it a dispute about the assessment of the impacts, or is it a dispute as to whether it's on the site or not?
It's both of those things, because you see what Professor Parker says in his conclusion. There are no significance, regional or local level.
Yeah, I'm at such a much more basic level. There's a site. It's been called the World Heritage Site. It will have a physical area. We are talking about a road. The words that are used in the decision letter, I think, are direct physical impact to the southwest corner. I'm still uncertain, I regret to say, Mr. Wolf, whether you are or not accepting that it is physically on the site.
Professor Parker says not. I think the issue may be this, my lord, and others can assist me if necessary, is that the description of F10 and its precise boundaries is not entirely clear because it's being put forward as an alternative.
Yeah.
So National Highways may say, by the time we've built out whatever you need to build out, it will impact.
Yeah, it was put forward as an alternative without being drawn up to the same degree of precision and detail as the proposed route, maybe.
So we don't know whether or not it will physically impact the site.
But that's not an unusual situation.
No. I'm not criticising Mr. Wolf. I'm finding it difficult factually to understand your submission. It is not a criticism. Nothing that I say is a criticism. It is a request for assistance, which I hope you'll be able to give. And if not, well, we'll have to manage. It's just not clear at the moment whether or not it's going to go on the site or not.
Just to help us all, I wonder whether, for the first time, actually, we might look at a map.
Well, can I leave that to others to deal with?
Of course. But it would, I think, just help us on this point.
Yes,
My Lord, supplementary hearing bundle 1, page 143.
Thank you. Yeah.
123?
Around 143.
Oh, 43, so sorry.
Or 42 and 43.
Yeah.
So my Lord will see on page 142, figure 4.6,
Yeah.
the corridor F routes,
Yeah.
and F10 was the northernmost of those.
Yeah, that looks as if it's... Is the purple the site?
The World Heritage Site is in
Crosshatched.
diagonal lines. Yeah.
Crosshatched.
So it says Stonehenge.
I see, okay, to the north end of the
To
purple
the
area.
north. So there's if you see where there's a slight, F10 goes very close to a corner where it, at the southwest corner of the World Heritage Site. So that was the disputed area.
Yeah.
But of course, this is a very high level options appraisal. And then, if my lords just want to compare that, the alternative to the proposed scheme, figure 4.7 on the opposite page, the lordships will see the D routes, which were the tunnel routes, as against F10, and the tunnel being the dashed line, and then the dual carriageway within the World Heritage Site being the black lines, or the alternative tunnel routes.
Right, okay.
The question really boils down to this, whether a road designed on that route, on that alignment, would necessarily or not just clip the southwestern corner of the World Heritage Site.
Yes.
Thank you.
So in terms of the other environmental effects, that they are recorded by the Secretary of State as part of his thinking, but he's got no evidence on them. He's not given any more information. And he sets out a conclusion, does not prefer, which it then follows is him simply adopting conclusions put forward to him by officials, which we say is impermissible. Now, can I just pick up how the judge reflected some of this in the judgment? Paragraph 186, this is page 213 in the bundle. Mr Strawn and Mr Taylor took the court to a number of documents which showed that there was ample evidence before the Secretary of State for Transport that F10 would have other serious environmental impacts, etc. But that's a reference to materials. I mean, whether it's right or wrong doesn't matter for the purpose of judicial review, but those are not matters that the Secretary of State, the Minister, was himself considering. He didn't look at those documents. The fact that they were available.
But if the officials had them and they say there will be these impacts, we're back to the whole discussion we've had before.
Yeah.
Either this is in effect a briefing document and it's saying there will be these effects, or it's not.
But the Secretary of State, well, I'm not disagreeing with my Lord's characterisation of it. We simply say, as a briefing document, it's not a lawful briefing document because it doesn't do the job. Because it presents the Secretary of State with conclusions with no evidence. Going back to what the court said in the National Association case, perfectly permissible to have briefings and summaries and so on, to provide the decision maker with a summary of the evidence for the decision maker to make a decision, not to provide the decision maker with the conclusion of officials simply to adopt. That's the problem here. So, Lord, just to put that in the context, I think I've picked up most of these points already in argument, but just to remind you where they are in the skeleton, we say this led the judge to err in law because of his approach to the materials, what the decision maker needed to have before him, as opposed to what he received elsewhere.
Where are you in your skeleton?
It's paragraphs 44 through 50.
Thank you.
I wasn't going to take you through them because I think I've picked up most of the points, but just for the note. Sorry, 44 through 56 if you want to have the whole section.
Yeah, thank you.
But I think focused it more on the approach to the underlying decision than necessarily on the judge. But if you want to see how we say the judge went wrong in relation to that, that's our appeal grounds. And in a way, the web links point comes in almost as a reactive point because the answer, we say, the answer isn't in the examination library in the way the judge hinted it might be, see paragraph 183, because of the web links point. So that goes to, while I was asked earlier on for some signposting, it goes to our ground, JR ground 8, which was the one added after commencement of the claim, at the point where we've been told what the Minister knew, the ministerial submission documents that the court's now seen. We didn't have those at the point we drafted the claim. Just for reference, in case it becomes confusing, that was referred to in the hearing below, at least by us, as an additional ground. It featured as, it wasn't called ground 8 in our skeleton, for example, below, but it became ground 8 in the judge's judgment. So they are relevant to that. They are also, and I've touched them, I'll come to the determination process in a second, they are also relevant to the second part of the process, the redetermination question, because the Minister was not properly briefed on what we were asking for, an inquisitorial process, but I'll come back to the primary argument on that in a moment. It's also relevant, Hutton will pick up a point in relation to the World Heritage Convention about the Minister's ignorance of the World Heritage Convention. Or aspects of that, I don't want to develop that at the time. And also what I'm going to come to briefly, which is JR Ground 6 in relation to the National Policy Statement and updates to do with carbon impacts. Can I then go on to the redetermination process? And again, you'll be pleased to know a lot of the ground has been covered on this already. In our skeleton, again, let me just do it by reference to our skeleton at the moment, we remind the court, this is paragraphs 57 through 60, of the approach to fairness. Protean concept depends on statutory scheme. Can I just pick up one reference, which is in Authorities Bundle 33, page 1218. This paragraph is partly grounded in Osborne, which you have elsewhere in the bundle. You see that reference to paragraph 80, but it goes a little bit beyond Osborne, which is why I'm taking you to it here.
Forgive me, am I meant to be looking at Citizens UK?
You are.
Good. That's a start.
You are. Sorry, I'm confusing things. So the passage I'm looking at, which is paragraph 81, 82 and so on,
Thank you.
is in part grounded in Osborne, which is mentioned at paragraph 80. That's the confusing bit. I'm sorry to confuse you. I want to pick up 82, if I may. The second virtue of fairness, underlying rationales for why fairness is important. They include that one of the virtues of procedurally fair decision making is that it's liable to result in better decisions by ensuring that the decision maker receives all relevant information, it's properly tested. Other interests at stake. Another important rationale is the avoidance of a sense of injustice which the person who is the subject of the decision will otherwise feel. Lord Reid put it this way: justice is intuitively understood to require a procedure which pays due respect to persons whose rights are significantly affected by decisions taken, etc. We say all of those things are in play here when the court comes to look at the fairness, and as we canvassed earlier on, that's the prism through which you look at this, the fairness of the approach that's been adopted in practice here. And it has all of those things, including sense of injustice, better decisions, and evidence properly tested.
What is it actually? It's given us reasons why fairness is very important. And we've seen those many, many times over many decades. What does this decide that's relevant? What's the proposition for?
The characteristics that the court is looking for and the benefits, if you like, the court is looking for in ascertaining whether a particular process in its particular statutory context is fair. Fairness is not simply, it's developed a long way since the kind of classic opportunity to respond to the case against you sorts of propositions. And this is illustrating that wider, more nuanced approach that courts now take to understanding fairness, and we say all of those things are in play here. We've set out in our skeleton at paragraph 70 and following a range of factors, and I'm not going to take you through all of them given the time, why we say, or how we say, fairness in this particular context required the process of the characteristics we canvassed much earlier in the day. Can I pick it up? Paragraph 70 of our skeleton, a note, statutory scheme. I won't take you back through the details of the statutory scheme, but DCOs in the ordinary course of events are premised on there having been an examination. And the statute doesn't tell us what that means, but if I can just ask you to look at it for one moment. This is tab 2 of the Authorities bundle.
Tab 20.
Tab 2, I'm sorry.
2, sorry.
Starts at page 25. There's a statutory choice about whether the application is being handled by a panel or a single person. That's section 61. And then section 74, in a panel case,
Hold on.
the panel has the functions of examining the application making a report to the Secretary of State on the application, setting out the panel's findings and conclusions in respect to the application and its recommendations as to the decision to be made on the application. And then there's a process of deciding within the panel. We say that is important because when we come to section 103 and 104, it is premised on there having been that process and that kind of report to the Secretary of State. Now, the statute is silent on what happens post-quashing, and we do not say there needed to be, indeed there couldn't be a statutory examination because that's, by this point, statutory history. But when the court approached the question of fairness in the redetermination process, that's part of the picture. I've already shown you, I won't take you back to it, but just the reference. Authorities Bundle, page 2487. That was the guidance to examining authorities on probing thoroughly.
You want us to go there again?
No, I just wanted to note it, to recall it at this point in the submission, if you wouldn't mind. These are all in our skeleton, paragraph 70 through 80 or so. The third point, on alternatives, there had not been any examination of the merits of the alternatives. In other aspects, there had been an examination and then there was a redetermination question. Here, because of the legal error made by the examining authority in the Secretary of State first time round, that hadn't happened. I know I've shown you all of that already. There were here, this is our paragraph 80, and I won't take you through the details, but the headings, a series of contentious issues on which either the Alliance or others had put forward significant material which we say needed to be considered in the context of an inquisitorial process because of what it raised about the National Highways point. You have archaeological remains, that's our 80 sub A. I've shown you the consortium submissions in relation to the Beaker period settlements. We looked at that earlier in the day. Our 81, traffic forecasts. I've mentioned that. 82C, groundwater. National Highways had released significant new materials in the redetermination process.
What groundwater's gone?
Our expert specifically raised the question of this needing further scrutiny, specific scrutiny. So this is in supplementary bundle 2 at 226, but it picks up at 233. What was specifically made 233 that there needed to be formal scrutiny of the new material.
Sorry, 233?
233 in bundle 2.
Yes, I got bundle 2, and you are saying 233, 233.
That's what it, yes. Middle of the page,
And
from
then,
the from the
yes,
above
paragraph on groundwater.
from the
Yes.
above referred to reports, and then the bottom of that paragraph. Enormous amounts of new data, formally scrutinised by an appointed examining authority to enable the Secretary of State to receive independent specialist advice.
Am I completely wrong, Mr. Wolf? I thought a groundwater issue had just gone. You were relying on it for point 8 and aren't anymore?
Well, in relation to this aspect of it, we're certainly relying on it in the context of saying it was one of the issues which had been specifically raised as being something that needed to be conducted through an inquisitorial process. I'm only relying on it for that extent.
And you say was not adequately dealt with in
Exactly, in the process.
either the ministerial briefing or the DL.
It's not quite a ministerial briefing or DL point. It's about the process which leads up to that. But I recognise they inevitably interact. But it's part of the picture. If this is simply, in one sense, to show that there were real issues that needed to be interrogated in that way. I don't go any further than that. Well, the judge. We say got it wrong as far as I'm dealing with the judge's analysis of this. The judge at paragraphs 119 and following of his judgment, this is Core Bundle 200 thereabouts, no doubt our inadequacy, but he treated this point as if our submission was an opportunity to have a hearing and cross-examine. So, for example, paragraph 119, opportunity to put their case and cross-examine. That wasn't the crux of the point. Similarly, 1, 2, 3, foot of the paragraph, issue-specific hearing. It's not about issue-specific hearings. Similarly, 127, 6 lines down, issue-specific hearing, and 136, same again. In terms of the judge's approach to that, let me just pick this up if I may. This is our appeal ground 3. Paragraph 115 of the judgment. The judge says this: it's well established that a claimant complaining about procedural unfairness needs to show he's thereby suffered material prejudice. Goes back to cases like Hopkins Developments. Now, our primary position is, even if that's right, even if all of that historic thinking is still good law, and I'll come to that in a second, we did suffer procedural unfairness here. We were materially prejudiced by that process. But we say those cases need to...
What was the prejudice?
I'm sorry?
What was the prejudice? Anything other than you've already said about the lack of an inquisitorial investigation?
Everything I've just said.
Everything you said, nothing separate from what you've just
nothing
said?
Separate from what I've just said.
Matters already referred to, yeah.
Yes, so the point to kind of lead to the rest of 115 in the judgment, there is no such thing as a technical breach of the rules of natural justice.
Yeah.
So if there had been nothing in issue, nothing that would have been interrogated, none of the kinds of points that I've referred to, this was a pure theoretical point about process, then absolutely we say, well, there'd be nothing to go. But that proposition of material prejudice cannot be erected, we say, into a, as it were, a substantial hurdle over which a claimant has to overcome. If it survives at all, and I'll explain why I say this in a moment, it is very much almost a prima facie case point. If you raised, as we have, issues which we say needed to be resolved through inquisitorial process, the proper approach of the courts now is to look at it through the prism, we say, of section 31, 2A and 3C, of the Senior Courts Act. Defendants say, oh, that's about relief, not about substantive illegality, but we say that's not a difference on analysis here, because all the court is trying to do is to rule out the possibility that this is a bare claim of procedural unfairness. And this is clearly not a bare claim in our case. If at all, the court would tip in here to look at this and ask you to look at Authorities Bundle 38 through the prism of section 31, 2A or 3C, depending on where we are.
Authorities Bundle 38, you mean tab 38?
I mean tab 38, my lord, is absolutely right. Jump straight in at page 59, if I may. Sorry, 1590, if I may.
Sorry, where are you jumping?
Page 1589 and then to 1590.
Thank you.
This is the Court of Appeal's decision in Plan B Earth, where the court, under the heading Relief at the foot of 1588, analysed the old simplex test and then looked at Senior Courts Act test, and then at 273, paragraph 273, which is what I'm...
And sorry to sound like a crack record, what was it said? I mean, section 21 talks about would the outcome being different if the conduct complained of had not occurred. What was the conduct complained of here, where it was said that there'd be no difference or highly unlikely?
In Plan B Earth, it was about the. It wasn't a fairness question.
No,
it was about the approach to greenhouse gases and climate change. It was a statutory question.
Right.
So this was a case about the general approach to Section 31.
Well, nothing is about a general approach. It's always based on facts. So this was an approach to the assessment of greenhouse gases under the statute, not a question of fairness.
That's right, my lord. But 273 in my submission is saying something a little bit more general than simply about greenhouse gases, if I may put it that way.
Yeah.
And so it's been taken subsequently to be saying more than that. And it makes the point, you've got the paragraph, that the threshold is a high one.
Well, it said it would not be appropriate to give any exhaustive guidance. Much will depend upon the particular facts, yeah.
Parliament's not alter the fundamental relationship between the courts and the executive. Courts should be cautious about straying, even subconsciously, into the forbidden territory of assessing the merits of public decision-making. It's been an error of law, for example, in the approach the executive takes to the decision-making process. It will often be difficult for the courts to conclude it's highly likely the outcome will be substantially different to the executive to come back to decision-making in accordance with the law. We say that prism is the prism through which, if at all, one assesses the impact of the unfairness. Well, as I told Miss Hutton, I'd give her two hours, and I'm going to give her 2 hours, so I'm going to do 15 more minutes, just so you know where I'm going, and then Miss Hutton will be on her feet at 3:45. Lords, final point within my suite of points, which is Appeal Ground 7, JR Ground 6, dealing with a separate point, largely. In the decision letter, Bundle 598, paragraph 21. We see the Minister picking up references to a number of policy documents. It's paragraph 21, sorry. Yeah. About 6 lines down, refers to various things with which I'm not concerned, the Wiltshire local plan, regulations and so on. I pick it up with the words a review. A review of the NPSNN is currently underway, and a new draft version was published on the 14th of March 2023. It's in draft form, has not been designated for the purpose of Section 104 of the 2008 Act. Secretary of State has had regard to the draft NPSNN in considering the selling application, notwithstanding any proposed amendments to the assessment, mitigation or decision-making process set out in the draft NPSNN. He does not consider there's anything contained within the draft of the NPSNN documents that would lead him to reach a different conclusion on the application. So we are concerned with those 6 lines. Can I just put this then in its statutory context? Back, if I may, to the Planning Act. tab 2, page 9. This is concerning the process of review of an NPS and the implications for DCO decision making in a situation, and I very much emphasise this, in which the trigger for a DCO review is international law or a change in international law. The points I make are not about the general situation of a NPS which is under review. They are about an NPS which is under review because of a change of international law, and I'll explain why that's relevant in a moment. These points go to the coherence of the statutory scheme. And we say section 104.4 of the Act, 104.4 of the Act.
Blimey, I'm in section
Yeah,
6.
you are, my lord. Has to be read alongside the provisions I'm about to look at. They are not hermetically sealed. And you can have a situation, and we say this is one such situation, in which an NPS which is under review but has not been suspended, and I'll show you this in a second, can nonetheless be critical, the review and the reason for it in particular, in the DCO process. Back to the beginning of that, section 6, review. The Secretary of State must review each national policy statement whenever the Secretary of State thinks it's appropriate to do so. Review may relate to all or part, and then there are separate provisions dealing with all or part. Sub 3, in deciding when to review a national policy statement, the Secretary of State must consider whether, since the statement was first published, there's been a significant change in any circumstance on the basis of which any of the policies set out in the statement was decided. The change was not anticipated at the time, and if the change had been anticipated at that time, any of the policies set out in the statement would have been materially different. I won't take you to them, but in section skeleton paragraph 142, we refer you to two decisions, one in Client Earth and one a Spurrier decision, in which the courts emphasised the central importance, the key importance of the third limb of those requirements, not to the prejudice of the others. But if the change had been anticipated at the time, any of the policies set out in the statement would have been materially different. That matters here. Sorry, the other bit of the statute, let me just look at before we leave the statute. Paragraph, page 19, section 11, gives the Secretary of State a power to suspend an NPS while it is being reviewed. And this NPS had not been suspended while it was being reviewed. But, we say, that is not the end of the story, because of the circumstances in which it was being reviewed, and more particularly the trigger for its review. We go look then at the relevant extract of the NPS itself. You've got this in bundle 3, page 208.
Sorry, just a minute.
Page
Sorry,
208. That's the beginning of the document.
I have to reconstruct a folder.
Oh, I'm sorry.
And one line will see that. Could you just give me page one?
Page 208 in bundle 3.
Thank you.
You see that this NPS was produced in December of 2014. That matters because we then, when we look at page 214, paragraph 516, at that point, it was correctly stated, the government has a legally binding framework to cut greenhouse gas emissions by at least 80% by 2050. As stated above, the impact of road development on aggregate levels of emissions is likely to be very small. Emission reductions will be delivered through a series of 5-year carbon budgets set that are projected to 2050. And you see, just in the footnote, that's a reference back to the then carbon budget delivery plan, or the equivalent, of 2011. Just before I leave these pages, so I don't need to come back to them, paragraph 5.18, decision making. So this is the thing that's driving a decision under section 104, unless there's a reason to displace that. The government has an overarching national carbon strategy as set out in the Carbon Plan of 2011, now long since superseded, which is a credible plan for meeting carbon budgets. It includes a range of non-planning policies which will, subject to the occurrences of the very unlikely events described above, ensure that any carbon increases from road developments do not compromise the overall carbon reduction commitments.
You've lost me again, I'm afraid.
Sorry, it's 518,
Of bundle,
paragraph 518.
of bundle page and
Same
bundle
page, 215, next page. 215,
of.
Bundle 3.
bundle 3.
Thank you. That explains why I'm having a bit of trouble.
Apologies. It was
My fault.
reading on from the previous
Yeah, no,
section.
it's fine. Yep, thank you.
So, against carbon commitments, which were specified by reference to the then 80% statutory carbon target, very unlikely that individual developments will compromise carbon reduction targets. But since then, the 80% figure has been changed by a statutory amendment, and indeed there have been many subsequent carbon plans to pick this up, to 100%. But critically, the trigger for that was the Paris Agreement. We see that, and I just picked this up in the case, the net zero strategy case, which you have at Authorities Bundle tab 46, page 1880.
Are we coming back to that?
We're not coming back to that bit of MPSNN, but you'll come back to that bundle. Apologies for that.
Okay. Sorry, the 46, was it?
Tab 46, yes. Page 1884, paragraph 5, just really for the factual record helpfully accounted here by the judge. The Paris Agreement was 2016, and then at paragraph 5, the UK responded to the Paris Agreement in 2 ways. First, section 1 of the Climate Change Act was amended so it became an obligation of the Secretary of State, etc., to ensure the net UK carbon account is 100% lower than the baseline, in substitution for the 80% reduction. So the 80% figure, which had underpinned the NPS 80%, has been changed to 100% to give effect to the Paris Agreement. The trigger is important. The Paris Agreement trigger is important. Back in bundle 3, supplementary bundle 3, page 240.
204.
240. You see the announcement of the review of that 2014 document.
Sorry, just a second.
Page 242, you see the explanation of that, second paragraph, the current NPS was written in 2014 before the government's legal commitment to net zero. And that's a reference to what I've just shown the court, because the 100% reduction equates to net zero triggered by the Paris Agreement. So that was the trigger. And in reaching the conclusion to review the NPS, go back to section 6 of the Act, the Secretary of State must have been of the view, first of all, that there had been a material change. Well, there had. Secondly, that this was not anticipated, which it wasn't. And thirdly, had it been anticipated, it would have led, it's high language, to a different NPS. So that was the trigger for all of this.
Page reference, you wanted to take us back to the statute.
It's page 6, is it? It is 9. Page 9 of the Authorities Bundle. Section 6.2, Section 6.3c. That all matters because of, in the Authorities Bundle, tab 2, our friend section 1044 of the Act, which you have at page 64 of the Authorities Bundle. If the Secretary of State is satisfied that in deciding this application in accordance with any relevant national policy statement would lead to the UK being in breach of its international obligations.
So are you saying because there's a review of the policy statement, because of the 100% change, any application, which relies on the pre-NPS review will necessarily lead to a breach of section 4?
No, not necessarily, no. Not, so it's a much earlier and simpler point than that,
right.
which is that section 1044 required, proper exercise of the 1044 function required the minister to be aware of the trigger for the review. That pulls it together. Because, and only because, the trigger was an international law change, international obligations change.
Yeah.
And the point about section 6 and section 11 is that that is not changed by the fact that the Secretary of State, not this minister, the Secretary of State, had not suspended the NPS.
But it's either a breach of section 1044, it's not, isn't it?
It required, the breach of section 1044 is the minister not addressing his mind to the question on a properly informed basis.
That's not what it says. It says this section applies if he's satisfied that deciding the application in accordance with any relevant national policy statement would lead to a breach.
Yes. And in order to undertake that evaluation, the minister needed to be aware, we say, of the, in this instance, not in every instance, but in this instance, of the trigger which had led to the NPS review.
The trigger being that there might be.
The trigger being, go back to section 6, that there was going to be a change in the NPS provoked by Paris. That's why we look at the trigger conditions for the section 6 process.
This is positively Kafkaesque.
Yeah.
Because the starting point has to be that the Secretary of State is satisfied. And you say, aha, we can find a bolt hole or whatever pejorative term you like to use, if he hasn't satisfied himself properly. And if he hasn't turned his mind to Paris, he hasn't satisfied himself, and therefore this section applies. Is that right?
Well, he hasn't. So not quite, because all this really leads him to, and if I can just get to the next step, is he needs to be properly aware of, in this context, the provisions of the revised draft, which we are told by the statutory process are going to be different. And this is the statutory route that gets him into that, notwithstanding the fact that the existing NPS hasn't been suspended pending review.
Well, he's got
So
to
this
decide it in
it's not an abstract.
So he's got to decide it in accordance with the non-suspended in force relevant national policy statement, unless he's satisfied that doing so will lead to a breach. That's what he's got to do.
Yes, and in order to get to that place...
Whether there might be a breach, or goodness knows, we don't know whether there'll be a breach or not.
No. Well, he hasn't asked the question. That's the point here. He hasn't asked the question.
This is too clever for me by half. Can you just help me to my simple trying to get a grip of this? We're looking at section 104. Section 104 says you've got to apply it, you've got to comply with the national policy statement, unless for 4 to 8. The starting point, as it seems to me at the moment, and this is maybe where I'm going wrong, is that there was a policy statement. So the starting point was there was an obligation to comply with it, unless you say the Secretary of State is satisfied that deciding would be put him in breach of his international obligations. What has the review of the policy statement got to do with whether or not the United Kingdom is in breach of its international obligations? Surely there's a much more direct line, which I thought you were going to say, is Paris creates international obligations. He should have been satisfied. He hasn't turned his mind to it. Therefore, never mind about suspension or non-suspension or implication of the policy statement. We're straight into policy. I just...
Well, my Lord, I'm sorry if I've made it more complicated. My Lord has the point, and I'm sorry if I made it a complicated way. The reason we get into the Section 6 in the review process is because the answer to my Lord's point, which in sense with our point, might be, and indeed the judge approached it this way, yes, but you can't say that because the NPS hasn't been suspended and therefore you're implicitly and unacceptably challenging an unsuspended NPS, which is impermissible.
Well, you're not challenging the unsuspended. You've got an unsuspended NPPS, which everybody agrees. And then the question is, you've got to apply that unless Section 4 applies. And that's got nothing to do with suspension or triggering or this, that, and the other. It's a simple question.
Yes.
Did Paris create international obligations? Should he, either was he satisfied? No. Or should he have been satisfied? Different question.
Yeah, absolutely.
Can I hang on to that?
Please do. I'm happy with that. I'm sorry if I've made it more complicated.
The review is a review on policy for national infrastructure projects generally, isn't it?
Well, within the scope of this NPS.
Within the scope of the NPS.
So this NPS doesn't apply.
It's not just going to be a review of the national policies thing that applies to the Stonehenge road stroke tunnel. So this talks about, will this application lead to a breach?
That's why the question, my Lord...
the question really, isn't it?
Yes, and that's why the question my Lord puts to me is not a generic question about the NPS. It is focused on this decision, that it must be. And it's in the context of this NPS, which is not all infrastructure projects, it's all road and rail, major road and rail projects. So the scope gets narrower and narrower. And I'll finish quite quickly, if I may, because I just want you to look, if we could, at the draft revised NPS, which is on page 271 of...
Could you also show me the ground of judicial review and the ground of appeal as to what is the ground in the challenge here?
Yes, if you want me to.
Yes, well,
page 156 of the core bundle, the ground of appeal.
Find the core bundle now.
126, I'm sorry.
Judge meant that there had been a significant... Well, we don't know, do we?
But we do know, and that's the point about Section 6, because in order to trigger the review, the Secretary of State needed to consider whether the unanticipated change in circumstances would lead to a change, and he'd satisfied himself with that. So we do get to there.
But just the link with the project, the particular thing, I can't see the link between, I've got to review my document for rail road infrastructure with this application.
That's not accurate. I'm sorry, I am making this more complicated than it needs to be. The review was nothing to do with Stonehenge.
Exactly, yes.
However, for this decision, and my Lord Justice Stuart-Smith has the point better than I'm putting it, is the Secretary of State and the Minister needed nonetheless to address himself to the 1044 question in this context. the unsuspended NPSN was not an answer to that, because of the way 1044 works, that would have got him, by this point, it's in bundle 3.
Sorry, you'll have to go much slower. I'm really, really sorry. I've got the Minister needs to address the question. Just remind me, what was the question? Whether there was a breach of... whether the application... Was he satisfied that the application would be in breach?
The international law position. Just summarise it for
well, no, it's more accurate then. Was he satisfied that approving the application would be a breach?
Yes.
That's what he actually had to ask.
And he didn't ask himself that question.
But that's not what you put in ground 7.
No.
Is it?
Because ground 7 takes you to the point I'm trying to get to, if I may, which is what is this NPS review process generating? It's generating a document of which you have an extract, which at page 230 in bundle 3 set out the proposed new development control test.
Sorry, 230.
230 in bundle 3.
So what is this document? This is the draft new policy, is it?
Yeah, so by the time of the Minister comes to look at this, there's a consultation draft in which the test we saw at page 215, the 518 test, which had been framed by reference to the 80% test, was being proposed to change. And that meant, we say, and that's why we get into the appeal put in the way it is, that the Minister himself, and that matters, the point I'm about to take you to, needed to consider the impact of the proposed draft NPS-NN test as opposed to, or in addition to, the extant one, and the 104 presumption in favour of the existing one was potentially disengaged.
So it's the words against the net zero target in 5.35, that's what he should have applied, not the 80%.
No, it's the approach where in 517 of the 2014 document at page 215, last 5 lines, any increase in carbon emissions is not a reason to refuse development consent unless the increase in carbon emissions resulting from the proposed scheme are so significant it would have a material impact on the ability of the government to meet its carbon targets.
Right.
And that was written in the context of the 80% target and no longer featured in the draft material you have at page 230, which is the analogous provisions of the then proposed replacement.
But never implemented.
I'm sorry, my lord?
But never implemented.
Well, at the point of the decision, this was the situation.
I just have real difficulty. He can't apply 5.35 words on the page because it's a draft, and the Act says you've got to apply the policy. He doesn't have to apply the policy if he's satisfied that it would breach international law. So he then needs to consider international law. Or indeed, the next section has to consider whether it's a breach of duty or the next section unlawful. It either is a breach of international law or is a breach of duty or is unlawful, and if so, then he doesn't have to apply it.
And all I'm seeking to do is to show the court that this isn't, as it were, an abstract proposition, because the 1044 route, we say, should have taken him, had he properly understood what the trigger was for the NPS-NN review, to the contemplated draft with its changed policy. If I couldn't show you the changed policy, then it would be said, well, this is all completely theoretical.
Draft.
Yes, but it was the... So go back, if I may, then to paragraph 21, and I've now eaten completely into my son's time, but there we are. Paragraph 21 of the decision letter.
Yes.
Review of the NPSNN is currently underway, and a new draft version was published on 14th of March. It's in draft form, it's not been designated. The Secretary of State has had regard to the draft NPSNN. And this is where our ground 8, JR ground 8, on the Minister's knowledge, and if you like, the links argument, interfaces here with this ground. This is another example of where what the Secretary of State, the Minister, is signing up to is a paragraph in a decision letter in the context of him not having seen. There is no evidence that the Minister has been provided with. The court's seen the briefing materials, the draft NPSNN.
But he says he's had regard to it.
My Lord, he's had regard. In a sense, it's of a kind with other paragraphs we've seen. He's seen a draft decision letter paragraph.
But wouldn't the
So
Secretary of State have issued the draft? It's not the Secretary of State for Transport, is it, that issued the draft policy statement?
My Lord, yes, but here we're dealing with a particular minister. Minister Merriman is the person who took the decision.
And he's in the Department for Transport, and his boss has issued a review of a national policy on infrastructure.
Yes. And we've seen, the court's seen the materials with which he was provided for the purpose of taking this decision, and he is not provided for the purpose of making this decision with that material, that document, sorry.
This is his own department's policy.
I'm sorry, Lord?
This is his own department's policy.
Well, it's not his own department's policy. It's the point that's been made against me a moment ago is it's a consultation draft. So it's not his own department's
No.
policy.
No, but it emanates from the department.
I'm sorry.
But there may be.
It doesn't come from the Department for Health or the Treasury or the
But there may be
Secretary
many things emanating from the Department of Transport all the time, and in our submission, the court can't proceed on the basis that every minister is aware of every document emanating from their department, particularly in the context of a department like transport, which is huge and multifaceted, does many things.
Even if he says he's read it, or he's had regard to it.
He's had regard to it, we say, through adopting this paragraph, and that's as far as it goes. Well, Lords, that's not a good time to ask Miss Hutton to stand up.
No, no, that would be very unkind. So we won't do that.
Look, can I suggest a middle position? Well, two things. First of all, it may be that I want to say one or two things overnight. I don't plan to, but you never know. The other thing is that there are some documents that relate to what you're going to hear now in the morning from both sides, some of which have been sent to you, some of which haven't. And it may just be worth taking the 2 minutes left to us from Miss Hutton, particularly Mr Harwood, to at least introduce those to you.
All right, yes, we'll do that, but we must stop at 4.
My Lord, thank you. Can I just check that your Lordship's got the corrected references to our skeleton?
Yeah.
Yes, thank you.
And the EOG case, and which was the 2022 Court of Appeal judgment. Just checking you've got that.
Yes.
We'd also like to hand up, please support paragraph 15 of the operational guidelines. Your Lordships have part of the operational guidelines, the World Heritage Convention,
Right.
in your authorities bundle. But
These are all agreed materials, are they?
as I understand it, yes. And then it's also been, my Lord, realised that the Federal Court of Australia case at tab 56 of the authorities bundle is the appeal court judgment, but the decision which is relied upon by Mr Harwood for Historic England is in the first instance decision. I apologise for that, but I'm handing out first instance.
Right.
My Lord, the first instance decision will be at tab 56, and the operational guidelines are at tab 58 of the authorities bundle.
Will they be uploaded into? Will my bundle be deficient?
My Lord, it would probably be best if they're not uploaded because then the page references will be out.
You send electronic version.
But we can send electronic versions.
That's right. But provided we're not going to get a tsunami of additional stuff, just give me the hard copies and that'll be fine.
Well, I think it's just that plus some amended references to Mr Holgate.
I don't think even in my most enthusiastic moments I would call that a tsunami.
Thank you.
Right, so we're simply going to put this in at tab 56.
Where does the federal court come into the appeal hierarchy? You've got the High Court.
It's first instance decision relied upon by History of England.
So is the federal court 2 below the High Court?
I believe it is, my lord.
I think
Well, perhaps someone could tell us
Check
tomorrow.
it overnight.
Yeah.
There seems to be two tiers. We passed up it's essentially the High Court level at this stage, so the first tier, and the Court of Appeal decision, however they describe it, doesn't do it. Now, can I pass up just two documents, one of which the court received on Friday, and the other is new. One's a single sheet, and then there's a clip. What the court received on Friday were the summaries of the World Heritage Committee decisions over the last two sessions. And just those go with the draft World Heritage Committee report, which the court's received from the appellants. And the other is that for paragraphs 42 and 43 of my skeleton, which deals with the Tasmanian case, I've changed added in the references to the version of the judgment which is in the authorities bundle. So it should be easier to find where those entries are.
So you said two things were sent from the World Heritage. What I received on Friday was a provisional agenda which included in the list of recommendations for the committee that's due to meet at the end of July, I think, in New Delhi. And then, so there's no decision as such yet.
That's correct.
And then I've now got another document about somewhere in China, an online meeting at Fuzhou.
Those are the previous two decisions, previous two committees. The point we make, and I'll be incredibly short, is that the World Heritage Committee is in the habit of not following the draft decisions which are put in front of it.
Right,
I'll
well,
deal with that in my submission.
Thank you. Thank you. Well, we'll read these materials overnight. In the morning, I won't attempt it now because that will make us late, I'm afraid. We'll do the housekeeping to find a place for them all. Perhaps you'd like to think about that. Is there anything else that we ought to receive before tomorrow morning? Good. All right. Well, as I said earlier, we'll start a little earlier to make up for the time that we're losing now. We'll start at 10:15 in the morning. 10:15. Thank you.
All rise, please.